Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. I'm not a fan of Adam Montgomery. Let me just make that clear. So let me preface my remarks with a clear statement that if Adam Montgomery is found guilty by a jury, he should be locked away forever. I'm not a fan of anybody who hurts children, and I'm certainly not a fan of anybody who actually takes their life. And so, without deciding whether or not he has done that, that's up to the jury. I'm just going to say if he's found guilty by the jury, he deserves every bad thing that comes with that. But before we get to the meat of this discussion here this morning, I want to have a brief review of something that is going to be important in just a little bit.
You admit to each and every element of the offense of falsifying physical evidence and abuse of corpse. Is that okay? And did you speak with your lawyers in detail about that?
Yes, I did.
As I have said before, many times in a criminal trial, the state will have a home field advantage. Close calls on evidence often go to them, unless the case is really horrible, in which the judge, if he or she is smart, will be much more careful about what gets in and what stays out. Now, recently I saw another lawyer on YouTube telling the story of a case where his client was at fault for an accident, but in presenting the case to the jury, he did everything he could to distract from that aspect and emphasize how bad the damages were. Now, I can understand how facts get discovered in the course of a case and you thought the guy didn't have liability. I'm sure he would not have filed the case if he thought the guy didn't have liability at the beginning. But they discovered these facts and he has to go forward anyway. So he makes the best that he can by virtue of going to the really emotional stuff, which is how bad the guy was hurt. But the fact is that when you are distracting on liability to emphasize damages, a smart jury is going to figure that out, and they're going to figure out pretty quickly just how weak your case is. I want to make clear again, I'm not cheerleading for Adam Montgomery. If he indeed beat his child, he is lower than the bacteria in whale feces. But at this point, he is not getting a fair trial. Yesterday, I pointed out that the prosecution was torturing the jury by proving up a bunch of forensic evidence proving the likelihood of death when that death has been admitted prior to trial. That was bad, but day 6 was over the top. Let me explain why with a reference to New Hampshire law. New Hampshire Rule of Evidence 403 provides that although relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, misleading the jury, or considerations of undue delay, waste of time, or needless presentation of cumulative evidence. Now, yesterday was needless presentation of cumulative evidence, but now we have basically the situation where when a court is making a determination as to whether to admit or exclude evidence, the trial court has considerable discretion, and they are entitled to a great deal of deference under New Hampshire law in determining whether the probative value is substantially outweighed by the danger of unfair prejudice. And so in that situation, an appellate court is not going to disturb its discretion absent an unsustainable exercise of that discretion. That's from a case called State v. Jordan, which is a 2002 case. Now, to show that the trial court exercised unsustainable discretion, the defendant has to be able to show that the ruling was clearly untenable or unreasonable to the prejudice of the defendant's case. Now, evidence is unfairly prejudicial if its primary purpose or effect is to appeal to a jury's sympathies, to arouse its sense of horror, to provoke its instinct to punish, or to trigger other mainsprings of human action that may cause a jury to base its decision on something other than the established propositions in the case. So that's the law in New Hampshire. It's also the law pretty much everywhere in the United States. Why is this important? Well, last night, as I often do when I'm looking for something to talk about on the next day, I watched Vinnie Politan on Court TV. Now, here's a guy who is a lawyer, he's now a journalist, and he's providing color commentary on cases on this channel. And being a trained lawyer, he knows that in a criminal case, it's vital to stick to the relevant evidence. He also should know or understand that anything that provokes an emotional reaction is an attempt to sway the jury to make an unreasoned decision. Now think about that. When somebody really gets your goat, when they make you just so mad you can't see straight, you often don't apply a great deal of logic and reasoning to your reaction. This is the reason a lot of people get punched in the nose. And if they had thought about it, if they were reasonable about it, they would realize that, saying something about someone's mother doesn't make it true, and it should be laughed off and walked away. But a lot of times people, when they have high emotions, just throw reason right out the window. So yesterday, the prosecution laid out the movement of the remains of Harmony Montgomery. And that was front and center of Politan's segment. Now, I'm not going to show you the video that he showed, but here is what I want you to see about that segment of Politan.
What happened here is beyond what should happen to anyone, let alone. She's not resting in peace, this little angel. Not resting in peace at all. And these details, this is beyond. And you have to ask yourself, when you hear the details of what was done with little Harmony's body and her remains after her death, why would you do this? Stuff her in a duffel bag, stuff her in a tote bag. Do all these sick, morbid actions.
Now here you have a guy who is trained to react objectively, and he's reacting emotionally. Worse, he's not seeing the big picture. Adam essentially pleaded guilty or admitted this conduct at the beginning of the trial. And his opening statement said the jury should find him guilty of transporting and desecrating the corpse. Putting this evidence into the case when he's admitted this conduct is for one reason and one reason only: to enrage the jury over the way the child's body was treated. Remember what the text of the opinion that we read said. Evidence is unfairly prejudicial if its primary purpose or effect is to appeal to a jury's sympathies or arouse its sense of horror, or to provoke its instinct to punish or trigger other mainsprings of human action that may cause a jury to base its decision on something other than the established propositions in the case. Well, I'm assuming that the defense, and at those multiple sidebars that are occurring in this case, is objecting to the evidence being admitted and hitting on Rule 403 and the standard in Rule 403. If the judge is letting the evidence in, not only is she violating Rule 403, she's also violating Rules 401 and 402. And here they are. Rule 401 says the test for relevant evidence is relevant if A, it has any tendency to make a fact more or less probable than it would be without the evidence, and B, the fact is of consequence in determining the action. Well, if you think about it, if you've already stipulated to the fact that he desecrated the corpse, evidence of how and why he did that, evidence of how he did that is certainly not important. It's not of consequence in determining the action, because you've already admitted the what, the why is not important. The state can certainly argue that it's guilty knowledge, like knowledge of flight, like flight from a crime scene is sort of evidence that you're guilty and you know you're guilty and that's why you're running, and that evidence of disposing of the body is evidence of guilty knowledge. But if you've already established that it occurred, then you have everything you need to argue that. You don't need to get into the how of what it was done. And Rule 402 says this: general admissibility of relevant evidence. Relevant evidence is admissible unless any of the following provide otherwise. the United States or New Hampshire Constitution, a statute, either federal or civil or state, these rules, or other rules prescribed by the Supreme Court. Now, what's not admissible? Irrelevant evidence is not admissible. And if it's not of consequence to the determination of the case, and clearly that isn't, then it's not admissible. Indeed, there is a jury instruction under New Hampshire law. It's instruction 1.07, and it says that a stipulation is evidence. It is an agreement between the prosecution and defense that certain facts are true. You must accept these facts as true. In this case, it has been stipulated that Adam Montgomery tampered with the evidence and desecrated a corpse. So if the state is relieved of proving that fact, then the evidence cannot be relevant. The fact of hiding the body and the fact the child is dead is effectively admitted. Proof of those things is not needed. And again, it gets right back to what I was saying before. The only reason to put that in is to make that jury so mad they can't see straight. Now, the state's counterargument is going to be, again, like I said, to show guilty knowledge, that it's relevant to show this guilty knowledge. But again, the how is not relevant. Only the fact that it occurred, the what, is relevant. The simple answer is that it should have been excluded, because the only reason was to horrify and enrage the jury in the same way that it horrified and enraged Vinnie Politan.
Do all these sick, morbid actions.
The state is likely going to get its conviction in this case based on the evidence that I've seen. Assuming these relevancy and admissibility issues were raised, there's a better than 50% chance that appeal will be an appeal of the conviction. It'll be vacated on that appeal. In my humble opinion, the public defenders set the state up, and the state was unable to see the trap coming. By admitting these two lesser crimes, they effectively took the heat out of the worst and most emotional evidence. And now that it's been admitted anyway, there's a good chance the trap's been sprung. And if the defense isn't objecting and isn't fighting this evidentiary fight, well, then Montgomery has a great claim for ineffective assistance of counsel. Now, a reversal might very well be a Pyrrhic victory for Adam Montgomery. All he would get out of a reversal would be a new trial. But that's going to be a year or two down the road, and who knows if Kayla is going to be able to come back and testify a second time. Remember, she's an addict, and yes, people who are addicts can get drugs even in prison. And that bodes ill for a long life expectancy, the fact that she is an addict. Anyway, that's what I have for you today. I hope you appreciate me sparing you the evidence of the way the remains were treated. If that information's not necessary to the legal issue, then I'm not going to burden you with it. Now on to something that's more important, my little kindness portion here. Have you ever bought a bag of dog food or cat food that your pet didn't eat? Maybe they hated it. In most cities, you can take that bag of uneaten dog food, whether it's Purina dog chow or Purina cat chow or Old Roy, you can take it to your local humane society or animal shelter, and they're going to be glad to have it, because hungry dogs and hungry cats will eat pretty much anything. That's an act of kindness that would benefit a lot of our furry friends. And while you're there, it helps to remember that rescues are the very best kind of pet to get, because you give them a shot at life. God bless you all. Thank you all for coming here, especially you new subscribers, and come back here tomorrow and join me down here at the beach. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.